Appeal number 57, the Burlington Insurance Company versus New York City Transit Authority. Counsel?
Good morning, Your Honor.
Good morning.
Joseph D'Ambrosio, Ford Marin, on behalf of the appellant, the Burlington Insurance Company. Your Honor, the legal
Mr.
question-
D'Ambrosio, may I interrupt you for a second? Would you like rebuttal time, sir?
May I have 2 minutes, Your Honor?
Yes, of course.
Thank you. Although the legal question in this case is one of contract interpretation, the practical question is whether there is any limit to the scope of additional insured coverage in the state. The result of the holding below by the appellate division is that in a situation where the subcontractor had zero fault.
Well, as I understand your position, counsel, it's that the additional insureds, if they're solely negligent,
That's correct, Your Honor.
that they then have no coverage. But is there the use of that term anywhere in the endorsement or anywhere in the policy about the negligence of the additional insured?
I don't think it has to do with the negligence of the additional insured, Your Honor. It has to do with the lack of negligence of any kind on the part of the named insured, the subcontractor.
Is there any reference to the negligence of the named insured anywhere in the language?
The language refers to proximate cause. The language.
Well, does it say proximate cause?
Well, what they're trying to define the term proximate cause, they don't use the word proximate in the definition, but they use the same terminology that is used in the patent jury instructions for defining proximate cause, the same in whole acts or omissions language. And I would submit, Your Honor, that
Well, isn't the language that we're talking about here is the policy language that says who is an insured, right?
Yes, Your Honor.
That's the language that we're talking about. I think that's what Judge Rivera is referring to. And that says caused in whole or part by your acts or omission. You would have us read that as saying caused in whole or part by your negligent acts or omission. Is that correct? Is that the reading you're asking us to put in there?
Yes, Your Honor.
So the rule that basically you're seeking from this court is that we can imply that term in this contract.
That's absolutely right, Your Honor.
Now, of course, I worked for Kemper as House Counsel at Kemper for about 8 years, and they were quite strict about applying that the words in the contract meant the words in the contract. And of course, it's an adhesion contract, so it has to be read against the carrier. But even leaving that aside, it seems a stretch in terms of the basic rules of insurance contract interpretation. I understand the policy reason. I think it's a good point, but I'm having a hard time with the basic rules of contract interpretation supporting your position.
Your Honor, I think what supports our interpretation, Your Honor, is that you have to give effect to all of the words in the endorsement. And as set forth in our papers, I submit that when you have language, triggering language caused by, it can only be one of two things. It could be but-for cause in fact, or it could be proximate cause, legal cause.
Well,
Well,
let's
that's-
assume for a moment that it is proximate cause. And as lawyers, we tend to equate that to a negligence situation. But to the average person, to an insured reading that, the plain, common understanding of caused by, does that necessarily indicate negligence? Or couldn't it be something, some causal relationship, similar or the same as really proximate cause, but not require negligence?
No, Your Honor, in the context of insurance policy, which, provides coverage for accidents, negligence, I think the context of it makes it clear that you're talking about proximate cause here and not just but-for cause, because this court has said, even when interpreting much broader language arising out of, that it was more than just but-for cause. You said that there needed to be a causal nexus between the accident and the risk for which coverage was provided. And we would submit that the test that the appellate division came up with respect to the narrower caused by language, it results in much broader coverage, because anything can be a but-for cause. It's unlimited. And
Well,
here-
arising out of, I think, the focus is not on the cause, but out of the circumstances, the enterprise in which the parties were involved. Whereas cause certainly suggests that there is some cause and effect, so to speak. And regardless of whether you call it but-for or proximate cause or what you call it, to me, I think that we've pretty clearly said that those are two different things, but does that necessarily mean that it has to be negligent, that has to mean negligence?
Well, if it's not negligence, Your Honor, I'd say that the fault is that it's but for cause.
Well, it's, for example, the situation we have right here.
Yeah.
Okay? So the excavator hit something, it wasn't their fault, they were doing what they were supposed to do, there wasn't negligence, but certainly it did cause the explosion to happen. It was one of the causes that caused it. It was somebody else's negligence that led to that, but it was one of the causes, that's what,
Sure, I
that's
think
the
that,
situation.
I think what you're saying is, that it's but for cause, and I think it was a but for cause. We don't dispute that it was a but for cause.
But that's different from arising out of. It's more narrow. You're suggesting that it's broader. I'm suggesting that it is more narrow than arising out of, which doesn't necessarily require even but for cause.
But the reason I even started with the arising out of comparison, Your Honor, is because in this court's decisions in Worth Construction and Regal Construction, you came up with a test that I submit is more than but for cause. You said there needed to be a causal nexus. And under the Worth and Regal holdings, I submit that under the facts of this case, there would not be coverage, even if we had what everyone considers to be broader arising out of language, because there was no negligence. Worth said it's not the subcontractor's fault, there's no causal connection, there's no nexus. And then in Regal, the court said, well, it's not just fault, not just negligence, if it's the subcontractor's employee. Well, this is an accident involving the transit's employee because of an elevation hazard and in terms of falling off a work platform, and it was triggered by their failure to de-energize the cables, which is their negligence. So you have what I submit is a situation that would not even fit under the broader arising out of holdings of this court, and yet we're dealing with, on its face, narrower language. We could debate about it, but
Any meaning do those other words, let's get back to the actual words in the policy and the endorsement, in whole or in part of the actual word liability. Liability to me seems to suggest, under the law, how you're going to be liable, which requires some negligence. So can you address those phrases?
Yes, Judge Rivera. One of the arguments we made regarding the plain textual analysis of this is that, the First Department read out of the endorsement the in whole or in part language. And why I say that is because only a proximate cause can be a partial one. You can't have a partial but-for cause. It just doesn't make sense. You can have infinite numbers of but-for causes, but they're whole or not. They're not partial.
Counsel, just step back and perhaps a very basic question. It's an additional insurance provision, right? Generally in the industry, what's the purpose of the additional insured provision?
Thank you, Your Honor. The purpose of the additional insured provision is to provide coverage to upstream parties for accidents that happen that are a result of your negligence or involve your work on the project, depending on the precise language. And now here we're dealing with language that was
And just to
modified.
stop at that point, though, first, before you get to the language, to stay with the purpose. So I don't, this is very specialized business, but an upstream, as you call it, party who's looking to become an additional insured, it seems in some of the cases, this is because something may happen to the insured. The insured may have some type of, go bankrupt or something else. So it gives the additional insured rights against the insurer, to me, it seems, for the conduct of the primary insured.
Yes, Your Honor. I mean, it provides for coverage when there are actions on the part of the named insured, the subcontractor in most cases, that trigger the coverage depending on the precise language that's used. And I just want to point out that, this endorsement that you're interpreting today is an amendment of earlier language, endorsements from the 90s that was the arising out of language. The purpose of it was to narrow the scope of coverage. That was even conceded by the appellate division.
Yeah, but see, this is an analytical problem that I'm having with your argument, which is that you're arguing what the purpose of it is. You're arguing what the intent of the drafters is. And there's a Pennsylvania case that talks about the use of parole evidence in the analysis of an additional insured endorsement. And in this context, I think we're really restricted by the language. You're asking us to step outside of the construct of the language, and really our function here is to say, does this case turn on the cause by language, not whether it's the same meaning as arising out of or a lesser or smaller meaning. Our simple question in front of us is, does this endorsement for acts include just negligent acts or any act? That's what we're stuck with. And anything else is really beyond the scope of our purview here.
Our main argument, Your Honor, is the plain meaning argument. It's not, we provided the intent as background, but that's not the focus of our argument. Our argument.
So you don't argue it's ambiguous?
No, absolutely not. Our argument is that construing this to require any non-negligent act or a non-negligent omission renders it to be unworkable, because.
Well, then why not just put the word negligent before act?
And that gets back to the first point I tried to make, was that they're trying to, the drafters are trying to define the term proximate cause. They did not use the word proximate, because just like in the pattern jury instructions, you don't use the word the concept you're trying to define in the definition of it. It uses the
Sure,
same.
but you see the problem. The definition of proximate cause is a substantial factor. But for causation would mean any factor, not necessarily a substantial factor. So those differences, that's why I'm wondering if it's necessarily applicable to our strict interpretation of the phrases that are in dispute here.
And the phrase, I think the phrase, Your Honor, that I focused on is in whole or in part. Because again, I don't think there can be partial, non-proximate causes, not but-for causes. There can be infinite numbers of but-for causes, but there can't be partial ones. There's a number of different but-for causes that give rise to an accident or an event, but they're not partial but-for causes. That language is tied exclusively, signals proximate cause, and so the absence of the word negligent to modify acts or omissions, it's not necessary. It's
Thank you,
redundant.
counsel. Thank you.
Your Honor.
Counsel? Counsel, could the endorsement have been more clearly written? Yes.
Yes, Your Honor. I'm Charles Strigas on behalf of the respondents. Yes, it certainly could have. It could have used the word, it could have used the phrase that was used in Crespo, liability for the named insured's negligence. It could have used the word caused by reason of the negligence of, only for the negligence. In fact, there are several cases that we briefed where we pointed out where the court, where the language specifically excluded additional insured endorsement coverage for an additional insured that was solely negligent. They could have put that language in. They didn't. They didn't put in the words negligence. They didn't put in the words proximate cause. And
Counsel, no, let me interrupt you. Counsel, am I correct that in the requirements to the agreement with the transit authority required that the insured get insurance for additional insureds using the ISO form or its equivalent?
That is correct.
That's correct, okay. So that form and the group that's created it, the ISO, isn't it obvious that it's intended only to cover proximate cause?
I wouldn't think so, Your Honor, because
Well, you guys chose that form as your example, and that's what's intended by the form. How could it not be that you knew that?
well, Your Honor, certainly,
Why would you choose a form with language that's intended to mean proximate
We-
cause?
the additional insured, both the city and the TA, did not have that understanding that it carried forth a requirement of proximate cause. There's no substantial factor language. Counsel suggested that
Why would you choose a form then that is clearly intended to have that outcome?
I don't think it does have that outcome, Your Honor, because for example, in arising under, it's liability arising under. That doesn't suggest proximate.
Well, you all requested this, and correct me if I'm wrong, you all requested this form be used and entered or accepted the contract with this particular insurance before the first department had issued these cases, equating arising under with.
That is
with this
correct, but
right?
we were under the apprehension, the understanding that this language would require a showing of any type of causation.
So why the language in whole or in part? What does that serve?
Well, two responses. First, Your Honor, without it, if it's just caused by act or omission arising in the course of the work, then an argument could be made that there's only additional insured coverage if the named insured was solely negligent, solely at fault under all theories of liability. This avoids that confusion and creates a circumstance where even if the named insured was at fault or not at fault, but there was any type of factual nexus between its act or omission and the occurrence.
I'm sorry, perhaps I'm just not understanding your argument. You mean if without that language, caused by means negligence?
No, I'm
Okay.
saying if it was just caused.
Yes, caused
that-
by.
Caused by in the course of the performance of the work, then if, without the in whole or in part, it would only cover solely caused by the named insured. And that is not the intention. The intention was to cover any type of causation that has a factual nexus connecting it to the ultimate loss.
Could you explain your position on the difference between, if any, between the arising out of language and the caused by
I
language?
think that, as the First Department held, it's the functional equivalent.
Well,
And-
but haven't we held that it's broader?
Well, it's broader, but again, not requiring a showing of negligence, not requiring a showing of fault, not requiring a showing of proximate causation.
Well, which one is that? You mean both of them?
All of that. In other words, the arising out of and the caused in whole or in part, both of them are functional equivalents to the extent that it is no requirement that there be a showing of negligence or fault against the
So then
named-
why the change in language if they're both, if they're the same?
You know, Your Honor, I could change, I'm not trying to be flippant, I could change a sentence from either A or B has characteristic X to either A and or B has
But you have to look at
characteristic
the-
X. It doesn't change it in logic,
But you have to
or
look at the
is
context.
one.
Excuse
at
me,
least-
Counselor, you have to look at the context. Here, there were insurance policies that all contained the same language for a long period of time, and then all of a sudden, they were all changed to say something else. There had to be some reason to change it, didn't it?
Well-
I mean,
Well, to follow up, isn't it the Maroney case that we're specifically referring to here as the Court of Appeals case? Are you familiar with it?
I believe so, Your Honor.
Okay, don't worry, don't worry. I always hated it when somebody tried to test me like that. I think in that case, if you look at that case, and I think that it may represent a conflict with the Glass case and with the W.W. Glass case from the First Department. And in the Maroney case, I thought addressed the question specifically of whether or not policy coverage requires, quote, a negligent act or acts. And
Well, that was an arising out of.
Right.
And there, if I remember, the coverage for the barn did not include commercial purposes, and this was, in effect, being used as a,
I think you're right.
table.
I think you're right, Counselor. What I'm wondering is does the language in that case mean that we have to view arising out of and caused by differently?
I don't believe so, but even if you did, I don't believe that the interpretation of caused in whole or in part by the act or omission of the named insured arising out of the work requires any of the things that they're claiming. What they're claiming, in effect, is that any time a named insured is insulated from liability by the exclusivity remedy provision of the workers' compensation law, the injured party was their employee, or statute of limitations, or discharge in bankruptcy, the additional insured is left there without coverage.
And of course, the additional insured is a negotiated part of the contract that was paid for specifically to be covered, right?
You know, and I think the ramifications.
Well, I thought their argument was when the insured is in no way negligent, has no fault, is not to blame, but the additional insured is to blame, that then the additional insured shouldn't get the benefit of their own negligence.
Well, they were free to put in language to that effect.
But
There
counsel,
are
to
reported cases
follow-
where such language was included.
Counsel, you're running out of time, and I just want to ask this. To follow up on Judge Rivera's question, doesn't this interpretation, and it's not going outside the contract, it's just fundamental insurance kind of approach to me, doesn't this lead to somewhat absurd results? Because really what you're asking for is not an additional insured here. You're asking to be uninsured for your own negligence. So fortuitously, in this case, that party hit the wire that was left exposed. It could have been a completely different party that hit that wire, in which case you would not recover under this. And it's almost like the person walking down the street slips on the ice. They're a cause, but really collecting from their insurance company as an additional insured seems somewhat counterintuitive from an insurance perspective to me.
Well, I would submit that this carrier picked language that comprehends their obligation to provide additional insured coverage under the facts of this case. If they chose to do it differently, they could do so.
Yeah, but they pick language based on what you required is the form or its equivalent. And that, again, the drafters of that form and that language intended it to be proximate cause.
Well, that,
It must mean something that you wanted to use that form and that language.
because our understanding of that form and that language is not consistent with their contention of what the draftsman intended.
Is your
Draft-
position, I'm sorry, because your time did run out, is your position that the language is ambiguous or unambiguous?
It's unambiguous, and if any ambiguity exists, it should be construed against the draftsman.
Got it.
And that ultimately, the fact that, and there are cases that establish limits to additional insured where the occurrence did not arise out of the work of. That would take care of, Your Honor.
If it's unambiguous, I'm sorry, if it's an ambiguous following that rule that you just advocated for, it should be interpreted against the drafter, I get that. Should that hold when you said this is the form I want used, or its equivalent, this is the language I want used? Should it apply in that kind of a case?
I do, Your Honor, because there's no showing that any of the additional insureds, whether it be the city or the city expected to be insured. They weren't at fault. They expected coverage. They got it. Without, if you can indulge me for just one moment, should the court conclude that we're wrong on this, in effect, threshold issue that has been the subject of the discussion by the court this afternoon, I would submit that the fact that Burlington chose to discontinue their reservation of rights against one additional insured and not against another was improper, and that in and of itself gives rise to a voluntary payment, which they have no standing to be bringing this claim. But that's only in the event that I should not prevail on the first issue.
Thank you, counsel.
Thank
Mr.
you.
D'Ambrosio?
Your Honor.
Welcome.
Just a quick point on the other issues that counsel was referring to. The only issue before this court is the interpretation of this endorsement under CPLR 5501B. The other issues are internally inconsistent with the premise that there is coverage here. It's premised on the fact, on the argument that there is no coverage. So and I'll leave it at that. I just wanted to make note of Judge Garcia seemed to be dealing with this fortuity issue. And I think the hypothetical that we submitted in our brief about the light switch, I think illustrates the irreconcilability of this court's holdings in Worth and Regal with the interpretation of this narrower endorsement. You know, we had the light switch example where a carpentry contractor just happens to show up at work one day and he flips on a light switch unbeknownst to him because of something that the general contractor had done through the wiring the day before. It triggers a blackout, and a general contractor's worker down the hall is working on a scaffold that doesn't have a guardrail, and the lights go out, and he trips on a bucket and falls off the scaffold. Under the first department's interpretation of this endorsement, I don't think there's any question that there would be coverage under the carpentry subcontractor's policy. I submit to your honors that that is an inequitable result. It conflicts with the plain language of the endorsement. And one final thought.
Hey, but let me ask this.
Yeah.
You're on a roll. I hate to interrupt you, but, you know, so maybe the judge will indulge. You can finish your point. But couldn't this have simply been corrected by a minor change in the language of the endorsement?
I don't think there needs to be a correction. Would we not be here if if the word negligent were placed?
But answer my question. You
Yeah.
think it could have been simply corrected by a minor change in the endorsement, referring to either liability or negligence?
Yeah, I just don't think, Your Honor, that this ever came up.
But it would clarify it, wouldn't you agree?
I think it would make it clearer to judges and lawyers, but I don't think it would make it clearer to, business people, because in this case, Your Honor, I submit to you that the interests of the insurance company and its customer, the named insured, are aligned. Here, the named insured who has no fault, and it's the general contractor who has all the fault, he doesn't expect, and it's not even his worker, he does not expect that it's gonna be his policy that pays $1 million, or if it's a bigger case, $5 million or $10 million, which is gonna increase his premiums, and if it's a big enough case, it could drive him out of business. So I think in this case, the interest of the insurance company and its customer, the two contracting parties are aligned, and we know the intent of the insurance company was clearly to narrow coverage, and in this case, it aligns with the objective of the named insured, who wants to provide coverage to upstream parties, but only if it's his worker or it's his fault, not just for some fortuitous incident which leads to a but-for causation. And with that, Your Honor, I would submit on our briefs. Thank you.
Thank you, counsel.